So that's that. So with that, let's get to the Supreme Court stuff. God damn it. We're going to start with anger. So there's an ongoing battle in Illinois. I don't know if you guys have followed this. I've made a few videos on it. If you're not following it, you probably should. It's really, really critical. It's really, really critical to your Second Amendment rights and to the scope of the nation. Illinois has decided that it will just ban the sale of quote unquote assault weapons. Okay. I mean, I read shall not be infringed, right? What is it? A well-regulated militia being necessary to the security of a free state, the rights of the people shall not be infringed, right? Pretty fucking simple. Shall not be infringed seems pretty fucking straightforward. Or the right of the people to keep and bear arms, I should say. I left out the keeping and bearing of arms. It's kind of part of it that matters. But anyway, so the idea is, there's well-regulated militia is necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. No law, nothing, no act can infringe that right. And yet, it seems to me that banning the sale of certain arms, any arms, honestly, infringes on that right. Now, are constitutional rights absolutes? I want to say they should be. I do want to say they should be, but they're not considered to be. The question is, how much do we have to do under the court's analysis to find something to be unconstitutional? How far? And they developed these different tests. Levels of scrutiny is what they're called. But levels of scrutiny. You have a rational basis test, you have intermediate scrutiny, and you have strict scrutiny. Now, they have never determined what level of scrutiny is necessary for the Second Amendment, although we're closer to it. They've kind of developed a new scrutiny standard under Bruin. Bruin was the most recent Second Amendment case. It came out of New York State Rifle and Pistol Association versus Bruin. And the long story short is that any purported regulation on arms must comply with the traditional and historical regulations in place at the time that the Second Amendment was adopted. The answer to that is there are fucking none. There are none. You have to cite to tradition. You have to cite to history. And there just wasn't regulation on firearms, on cannons, on boats, on anything, on swords, knives. None of this stuff had that regulation. None of it. So we've got a problem in that all laws impacting this should be presumptively unlawful. Now, is the court going to actually uphold that standard? I doubt they will, but I hope they do. But that's the idea. So along comes Illinois, and Illinois decides to ban assault weapons, whatever assault weapons even fucking are. And we'll get to that in just a second. I got some big super chats here to take care of. Thank you so much. Magnum Norse, back to it. So anyway, Illinois decides to ban the sale of quote unquote assault weapons. And there was a little sort of snafu in the court where the lower court said, yeah, we're going to uphold the ban. And so then it gets appealed to the appeals court, and I think they just had to try to get a preliminary injunction on the law taking place. That's what they did. Yeah, they tried to get an injunction on the law taking place, and the lower court said, nah. Or no, my bad. The lower court said, yeah, we will. I'm fucking this up badly, but the lower court says, yes, we will put the injunction on. The law is actually paused. It will not take effect. And it will not take effect until, the court case is decided. We got to decide if this is even constitutional. Then the appeals court came in and said, hold on, fuck off, homie. we're not actually going to enjoin this law. And the appeals court then lets the law go into full effect. Now, there's this awkward period of like 3 or 4 days between these two decisions where it was technically legal to buy assault weapons in Illinois, and a bunch of people did. But now we've got a fucking problem, because now that the appeals court has come in and said that they did, that the law is not enjoined, the law goes into effect. And the law has the effect of stopping the sale of these rifles before the injunction occurred. So any of those guns bought in that period are technically unlawful, even though it was legal to buy them, according to Chicago law enforcement. Now, law enforcement gets the law right about as often as Lizzo eats a vegetable. So that being said, though, their posture towards these guns is that these are unlawfully purchased firearms. This is a fucking insane proposition, because the law was suspended. People went and bought them. Having them does not make them somehow not legal. That's fucking crazy. And it'll be interesting to see them enforce it. But if you are in Illinois and you happen to be one of the people who bought one of those guns in that window, be very, very careful. Do not talk to anybody about it at all. You may want to lose it in a lake or send it to someone in another state or something. I don't even know what you're supposed to do, actually. This isn't legal advice. You might be fucked. You might be fucked, mate. So now we're in a legal wrangling. And they sent this to the Supreme Court. Now, what you would expect the Supreme Court takes a limited number of cases per year, right? They take a very limited number of cases per year. And it's going to take a bit for this underlying case to get resolved and appealed and potentially go to the Supreme Court. All the Supreme Court has to do here is enjoin the law from taking effect until the lower court reaches its decision. That's it. That's all they have to do. The Supreme Court takes several First Amendment cases a year. They take sometimes dozens of Fifth Amendment cases and Fourth Amendment cases. They take tons of cases from all sorts of amendments, except the second. The second is this bastardized amendment that has had basically 5 cases, I think, since 1900. Since 1900, there have been maybe 5 serious Supreme Court cases that affect the constitutionality of keeping and bearing arms. You have Miller, U.S. v. Miller, which is a tragedy. That's the first one in 1939. You have D.C. versus Heller is basically the next one. You have McDonald, which is D.C. versus Heller is in 2008. McDonald's in 2010. And then you really have New York State Rifle and Pistol Association. So I guess it's really 4. And so we would hope that the Supreme Court would, just make a ruling that's consistent with their fucking opinion in Bruin. And they didn't. They just completely fucking cucked on it. They just decided to kick the fucking can down the road. So now it is illegal to buy whatever an assault weapon is in Illinois, despite the fact that there's basically no way that this law can comply with Bruin. It's just, it's inconceivable. It doesn't make any sense. Let's read the fucking article. The Supreme Court refused to block a local and state ban on assault weapon sales in Illinois. Now, there's like 4 cases in Illinois, and I believe they were all just aggregated together. So, rejecting an emergency request from gun rights advocates and a gun store. A vote count was not disclosed, and the court did not explain its action. Wednesday's move by the High Court is the latest example of the justices staying out of Second Amendment related disputes for the moment. Stop staying out of the fucking dispute and just define the goddamn law. They don't stay out of any other disputes. It's just the Second Amendment, and it's crazy. They have a clearly articulated standard in Bruin that it is almost impossible to meet, implying that almost all gun restrictions are presumptively unconstitutional. And you need a really, really fucking good reason and some historical background to do it. Does it mean that you have to have a nationwide ban on guns of some sort to have prior to the adoption of the Second Amendment to do this? No. But you could have a state tradition of banning some type of gun, banning certain types of firearms or whatever. You could do that. Like you could maybe find a state that had some restriction on certain people or anything. One of the best examples of a historical tradition would be felons. Felons lose a lot of rights. Now, did felons specifically lose gun rights in 1791 when the Second Amendment was adopted? I don't know that they did. Maybe they did. I don't know that they specifically lost their right to a gun at that point, but the idea that felons have lost significant rights over and over, that those rights are taken away from them at least during the pendency of their incarceration or punishment, at least for that point, is something that's in the historical tradition of the United States. That goes all the way back. If nothing else, you lose your liberty. You lose property all the time when you're a felon to the state. Some things are forfeited to the state, whatever. Sometimes it's a fine. Anything used in a criminal act is forfeited to the state. So there is some level of historical tradition on something like that. So you could maybe say, yeah, people could construct the law saying that if you're a felon, you lose gun. We have this already. This is already there, right? Like this is either from it's either from the National Firearms Act or the Gun Control Act. I don't remember which one, but it's there. That could probably stay. Now, I don't know if it should apply to felons who are done serving time and done with their parole. Like if you have your whatchamacallit, your finish out your sentence of 2 years or whatever, and then you have supervised probation for 5 years, and then you're done. So your 7 years of being monitored by the state is over. I don't know that you could sustain removing guns at that point from that point on. But that's a different question. That hasn't been challenged yet, but it's coming. But we have this problem, though. The Supreme Court said in Bruin that this type of legislation would be held up to a certain standard. Just on its face, it does not meet it. It does not meet it at all. Let's see what CNN said. God, I hate CNN. I hope they catch fire. In Minecraft, the justice's refusal to intervene in the Illinois case also comes while communities in several states are reeling from mass shootings, including in some places in attacks carried out with AR-15 style weapons, which are covered by the Illinois law. Just ignore the fact that the overwhelming majority of gun violence is a handgun. Like, this is insane. This is insane. They always want to go, like, it's always assault weapons, which I know assault weapons are not real, right? I know that that's not a thing. It's a very nebulous thing, but just think, here's what they mean when they say assault weapons for the sake of simplicity when discussing the topic in safe places, because do not let them go. Hold them to a standard. What is an assault weapon? Can you define it? What they mean is the scary rifle called an AR-15 and an AK-47. Those are the only two rifles that they think exist. These people have no idea anything about guns, and any gun that looks like any of those to them at all is one of those two guns. That's all they know. That's enough because they saw it on some movie or something. But that's it. That's what they mean. But these are actually rarely used to commit gun violence. The most common thing is a handgun, but they always target these. They know DC versus Heller. They would have a big fucking problem targeting handguns, but that's what they got. So here we go. According to a brief filed by Naperville, which passed the local ban, whether, quote, the Second Amendment protects the commercial sale of a limited category of assault rifles within one municipality's border has never been addressed by this court. Here we have a problem. Homie, if it's never been addressed by the court, where's your historical tradition? Where is your historical tradition? You don't have any test of this. So where are you going to point to? The gun rights advocates had asked for the law to be placed on hold while appeals and a challenge they brought to the ban's play on at lower courts. They argued those courts have ignored last year's landmark Supreme Court ruling that expanded Second Amendment rights. Since the Second Amendment presumptively protects plaintiffs' conduct, respondents must justify the challenge laws by demonstrating they are consistent with the nation's historical tradition of firearm regulation. This is what we were talking about. This is a perfect argument to the new application with the court said. But it doesn't, they haven't done that, and the Supreme Court hasn't weighed that out. And they can't. They can't. Nintendo Power says, what effect do you think Cargill versus Garland will have on Matt Hoover's case? If a bump stock isn't considered a machine gun or part, how the fuck can a business card be considered one when there isn't even a cutout on it? Yeah, that'll be a question. Like, is Cargill versus Garland decided yet? I don't think it is. I don't think that's decided yet. I might be mistaken on that, but yeah, I mean, your logic is sound. I can't remember what the thing's called. It's not called an auto seal, a lightning link or whatever. I don't see how that could be a firearm. It legitimately cannot be a firearm. But, you know, the ATF. But that's, you know, that's Chevron deference, baby. We got to find out who gets to define the terms. All right, anyway. But yes, I do think that that's critical, because if the court decides that the ATF doesn't get to just call single inanimate objects that, I shouldn't say inanimate because guns are inanimate, but these objects that are not guns cannot be a firearm. Like, this seems like the most obvious conclusion possible. Like, it's like, this is a firearm. It doesn't do what a firearm does. It doesn't go pew, pew, pew. There's no shooting that happens. It's impossible for this to do the thing that a firearm does. How could the government regulate it? But under the current interpretation, ATF could say, hey, a lower shittily painted soul drinker's torso is a firearm by our definition because we say so, and then it would hold. That's where we're currently at with these things. And it's fucking unreal that is the literal truth. That's not satire. That's not an irony tag. That's nothing other than a fact that if the government, specifically the ATF, defines anything as a firearm, then it is. Firearm. What isn't a firearm? How can you have a limit? How can you have a limit? At least a completed lower receiver has moving parts. At least it has parts that come close to making it into a firearm. I disagree that a lower receiver is a firearm, but at least you can say, okay, well, like you put on an upper, a barrel, a stock if you want, and you fitted a trigger and you got a firearm, right? At least you could say that. But if it goes this far, it's literally just whatever the ATF deems. What if they wanted to ban something else that they couldn't ban? They just call it a firearm. It's insane. It's insane. I hate this shit. It's fucking unreal. How do we get past this? I don't know, but we need the court to act, and they're not. They're just abdicating their responsibility left and fucking right. Quote, but because the banned arms are commonly possessed by law-abiding citizens for lawful purposes, it is impossible for respondents to carry their burden under Heller and Bruin. The reason for this is apparent from Heller and Bruin themselves. There is no historical analog to such a ban. 2022 Bruin decision instructed that lower courts look to the gun regulations that were in effect during the Constitution's framing to decide whether current gun law violates the Second Amendment. The defenders of the assault weapons ban countered that the challengers had failed to meet the procedural threshold for an emergency action from the Supreme Court. If this is the only answer, fine, but also fucking gay. Illinois Attorney General Kwame Rowell, look, if this is your attorney general's name, I don't know how to say it, but you've got a fucking problem. And maybe that's bigoted, but I don't care anymore. I just don't give a shit. Wrote in his court briefs that the types of firearms targeted by the state's prohibitions fell outside of the Second Amendment's protections for firearms that are commonly used for self-defense. The Second Amendment, can I get a chorus of people saying the Second Amendment has no necessary inclusion of a purpose for firearms? That is a misread of Heller. The Second Amendment. Why do we need firearms? Oh, for self-defense. No, fuck you. Stop saying that. It's not for hunting. It's for self-defense. No, stop it. It's for defense from tyrants. No, stop it. Do you know why we have a God-given fucking right to guns? Because we have a God-given fucking right to guns, period. The government does not get to take them away. Not because we need self-defense or we need national defense or we need protection from tyranny or hunting or sport shooting or anything. No, the answer is fuck you. That's my name. You do not get to take my things. Period, period, period. It says so on the goddamn promise of me being a citizen. That's the only answer. That's it. And for anyone who wants to bring up the well-regulated militia preamble, the well-regulated militia has zero to do with firearm or any other arm possession. The preamble just says a well-regulated militia being necessary to the security of a free state. That is a prefatory clause. It is not the operative clause of the sentence. It has nothing to do with the right to keep and bear arms. Scalia laid this out in Heller very clearly. They brought in tons of experts on English, from 18th century English experts to 19th century English experts to modern English experts. Everybody broke this fucking thing down, and the court determined that that prefatory clause has no bearing on the operative language of the Second Amendment. They're two separate concepts. And logically, when you look at it, you cannot come to the conclusion that the second one relies on or is influenced by the first one, because it doesn't make any sense. Because the state and the people are terms of art, and the state and the people are not congruent. They're not the same thing. So well-regulated militia being necessary to the security of a free state. There you go. The only thing you can draw from that is, well, a well-regulated militia is necessary. So therefore, everybody should be able to have firearms so that we have a well-regulated militia, but that doesn't make any sense. There's no because, there's no dependent on, there's no dependent phrase. There's no dependent terminology. There's nothing other than the right of the people to keep and bear arms shall not be infringed, period. And it would do us well to fucking remember that and to stop capitulating to these excuses that we have accepted. And one of the worst purveyors of those excuses is the NRA. The NRA has been the enemy of the Second Amendment for a very long time. And I'm fucking tired of people pretending that the NRA is a useful organization. Great. They protected some gun rights a long time ago somewhere. Thanks. They also have said stuff like, oh, well, video games are bad. We need to ban those, not guns. That's stupid, by the way. Violent movies. Well, guns are for self-defense and defense from tyranny. No, stop making excuses. Stop making reasons. Stop granting categories. Because if you make a category like, well, guns are for self-defense, then you get this fucking faggot argument from Illinois that says these are not commonly used in self-defense. Or if you say guns are for an insurance against tyranny, you go, well, these aren't the type of guns that stop tyranny, or any gun can stop tyranny. Why is it this specific type of semi-automatic rifle that needs to be there to stop tyranny? You can use other guns to stop tyranny. Any gun is, any gun in every home is terrifying to the politicians, not this particular gun. This particular gun isn't scary. It doesn't do enough, actually. So we're going to ban it because it's not actually particularly an anti-tyrant gun, because it doesn't go through 8 layers of fucking insider trading before it hits a politician. So it can't be used to defend you from the state. This gun doesn't kill IRS agents, or whatever weird thing they want to come up with, whatever stupid, shady fucking argument they want to use to pretend that the qualification that we all just capitulated to with a dick in our mouth is fine. They're not fine. Our rights exist because they are inherent. They are inherent in you by your birth. Not even your birth as an American. Your birth. We recognize the right of the people to keep and bear arms. Not the natural born citizens, not the Americans who were born here, but they weren't born. Everybody's born with the right. The U.S. just recognizes the right. It doesn't grant it. It doesn't bestow it. It doesn't create it. It doesn't sculpt it out of some narrow line of exceptions. No, the right is in you by the merit of your existence, period. It doesn't need an excuse. It predates excuses. It's not the right to protect your ability to live. No, Spacey, no. No, this is the problem. We keep trying to have I like your definition, but it's like you're adding nuance where nuance doesn't exist. Look, a watermelon is a watermelon. I don't need a watermelon that's cut in half. I need a seedless watermelon. I don't need a watermelon that tastes good, a watermelon that tastes bad. It's just a watermelon. It's just a fucking watermelon. There's nothing else. It's just a goddamn watermelon. Not a watermelon that's cored out and mixed up with fruit. Not a watermelon with salt on it. Not a watermelon that with a thin rind. Not a watermelon with no rind. Not a watermelon cube or chunk or piece or fragment. It's just a fucking watermelon. There's nothing else to it. An apple is a goddamn apple. Your right to keep and bear arms is just your right to keep and bear arms. It is not your right to self-defense. It is not your right to national protection. It is not your right to secure your home and family. It is not your right to secure food for your family. It is not your right to turn off the TV in a cool way. It is not your right to skeet shoot. It is not your right to sport shoot. It is not your right to speed shoot. It is not your right to quick draw. It is not your right to go out and have fun. It is not your right to mount on your vehicle. It is just your right to have, period. There is nothing else. Do not ever put a fucking qualification on it. We have done this forever as Americans. Your right to free speech is, well, your right to political speech or commercial speech or just casual speech. No, free speech, motherfucker. Do you speak it? There isn't a thing. There isn't a qualification. There isn't an okay and this. No, stop giving them arguments. The only time you don't have a right is when you have forfeited it by your intentional actions that are then prosecuted under all applicable criminal procedure until proven guilty beyond a reasonable doubt by a jury. That's it. This is the only time you lose your rights. And if we say, well, mentally unstable people, I don't know if they want guns. Stop. I just don't know if I want someone on drugs to be able to get guns. Stop. Because today it's drugs, tomorrow it's Call of Duty. And if you think I'm fucking kidding you, I am not fucking kidding you. Today it's drugs, tomorrow it's Call of Duty, next it's the Republican Party. Today it's drugs, tomorrow it's Call of Duty, next it's a book that complains about taxes on your shelf. Today it's drugs. The next day it's antidepressants. And the next day it's supplements. It's an herbal supplement to make you feel good. Any excuse is every excuse. Stop giving them ammunition. Stop giving ground. There is no ground to give. Liberty is liberty. Liberty is not subject to exceptions. Okay. All right. Okay, so the Court of Appeals will hear arguments on that case on June 29th. And we'll see if their argument stands at the Court of Appeals level. It will then be, of course, it will go up to the Supreme Court after that. No matter what, it will be appealed to the Supreme Court. Based in domestic terrorist. When anyone's a domestic terrorist who has not committed a terrorist act, everyone's a domestic terrorist. You're one statement on Twitter away from domestic terrorism. You're one joke about Proud Boys away from domestic terrorism. You're one retweet by Gavin McInnes from being a domestic terrorist. We have to wrangle the state. The Supreme Court has to help us wrangle the state.